Good evening, ladies and gentlemen, and distinguished guests. It is a pleasure to welcome you to the Larkin-Stuart Lecture for 2015, jointly hosted by Trinity College and St. Thomas's Anglican Church. This lecture series honors Cecil Stewart and Gerald Larkin, who served both our institutions well for many years, and believe that there is a necessary connection between the church and the university. Their friends established this lectureship to explore, in its broadest sense, the spiritual aspect of wide-ranging subjects. It is a testament to the shared understanding of Larkin and Stewart that ideas not only inform, but transform, both individuals and communities. Presenting transforming ideas is the work of the college, it is the work of the parish, and the object of these lectures. To introduce our lecturer this evening, it is a pleasure to welcome the new Provost of Trinity College, Mayo Moran, to her first lecture. Welcome.
Thank you so much, Father Mark, and it is, I think this lecture series is such a wonderful tribute to a remarkable friendship, and as you said so beautifully, I think to the shared interest in pursuing ideas. So that's wonderful, and I'd like to thank the Larkin-Stuart Committee as well for all of their work on this. Now, I have, quite frankly, a horrible task right now, which is to try to briefly introduce a very good friend and a remarkable Canadian, the Honourable Frank Iacobucci. Frank has said of himself that his career shows that he can't hold down a job. He's had a remarkable career, as I think we probably all know, in academia, in the judiciary, and in public policy, and I think definitely does count as a very remarkable Canadian. I'm proud of Frank because, like me, he's a West Coaster. He was, and like our Chancellor, there's a little bit of a theme going on here. He was raised in Vancouver, and he was educated at UBC and at Cambridge. And he practiced corporate law, which may seem a long way away from things that he does these days, in New York City before joining the Faculty of Law at the University of Toronto. He served as dean of that law school, as vice-president and provost of the university. And then he left U of T in 1985. He was snatched away by the federal government, and he became Deputy Minister of Justice and Deputy Attorney General. He was then snatched away again when he became Chief Justice of the Federal Court, and he was appointed to the Supreme Court of Canada in 1991. Now, in 2004, I believe it was, Frank thought that he might kind of step back from involvement in public life a little bit, and he stepped down from the Supreme Court of Canada, which was to the great good fortune of the University of Toronto, because we quickly grabbed him as our interim president, and so he was the interim president of the University of Toronto for a year, which was our great good fortune. And since then, I think it's fair to say that although he had a very, very distinguished career before he was on the bench, it has been equally distinguished and important since. I'm not going to go through all of the many, many important public policy projects that Frank has pursued. They've included everything from First Nations representation on juries, dealing with people with mental illness in the policing system, and many other very challenging issues. But in my humble opinion, there's nothing as important that he has done as his work on the residential schools issue. In 2005, I believe it was, is that right, Frank? 2005, shortly after he joined Tory's law firm as counsel, he was named the negotiator for the federal government in what I think was a very important and thoughtfully constructed brief, which was not just to settle what was then the massive residential schools litigation. That litigation at that point, the numbers of cases vary greatly, but they're somewhere between 12 and 30,000 from what the numbers I've heard. So the federal government could have said, just settle that litigation, but they didn't. They said, achieve a fair and lasting resolution to that litigation. And I think that is a different kind of task than simply settling litigation. And so for the next considerable period of time, and I was working on some of these issues at the law school at the time, Frank undertook a task that I think most people thought was quite frankly impossible. And at the end of that period, in 2006, the Indian Residential School Settlement Agreement was signed. There were over 70 parties to that agreement. It was the largest class action that was ever settled in Canadian history. And in my view, as someone who works on these issues as an academic, I think it was by far the most ambitious effort anywhere in the world to deal with a very profound and massive legacy of historic injustice. And so that agreement, among other things, created the Truth Commission and a number of other very important institutions that went far beyond just trying to settle the litigation. And so Frank, if I may, it's a great honor to have you here tonight to talk to us about your work and about the report of the Truth Commission. So thank you very much for joining us.
Well, thank you. Is this working? Oh, yes. Good. Thank you very much, Mayo, for that introduction. My wife couldn't be here tonight, so could you give me a copy of it? She's been rather incredulous throughout 51 years. We celebrated our 51st anniversary on Saturday. Well, distinguished guests, one and all, you're all distinguished. At the outset, I wish to thank Provost, it doesn't ring, I still want to call her Dean anyway, Provost Moran and Rector Andrews and their colleagues for my presence today as the Larkin-Stuart lecturer. When I looked at the names of the distinguished former lecturers, I feel I'm here under false pretenses, but I'm not going to refuse the honor. It's extra special coming from St. Thomas's Anglican Church and Trinity College, a most distinguished institution that is well known for its excellence and leadership in post-secondary education. I know that from personal experience. I have two former colleagues of mine. The Chancellor was a former colleague of mine at the law school, university professor. Stephen Wan was a former colleague. Stephen, too, you weren't at Trinity College, but you didn't do too badly by going to McGill. Anyway, but I'm also going to say I'm very proud. I have a degree from Trinity. It's not the earned degree, it's the honorary degree, but I'm very proud of that. So for those reasons, I'm very happy to be here. Now I'm going to give a personalized account of the topic. So I'll be using I a lot. But I hope it doesn't convey an egocentric view of this issue, because it's not at all intended to be. But I was involved very intimately, and I will be referring to my own feelings. I haven't done this publicly before, but I mean, I've given talk before, but the personal pronoun is used more in this one than I have ever used it before. So my topic, Indian Residential School, has been variously described as one of the gravest injustices in Canadian history, the most disgraceful, harmful racist experiment ever conducted in our history, and indeed cultural genocide. And it's safe to say that the IRS legacy has been a prime contributor, not just to the terrible relationship Canada has had with its Aboriginal people, but also to the miserable and shameful living conditions of many of our Aboriginal people. Since I first became involved with Aboriginal issues as a lawyer and judge, I quickly realized how complicated those issues are. My awareness of this complexity and challenge increased when I was Deputy Minister of Justice, and later as a judge, it increased even more because of the pressure of rendering decisions, which became the law of the land. Without any doubt, in my time in the law, of close to some 55 years, I have never encountered a series of more challenging or difficult issues than those relating to Aboriginal people. When one adds to the legal complexity the immensely serious social, economic, political science, sociological, anthropological, historical, cultural issues, it's an amazing constellation of what appear to be insurmountable and irreconcilable interdependent challenges. Moreover, in my practicing law, the Indian residential school assignment proved to be the most challenging and complex set of issues I've ever worked on as a lawyer. What was especially interesting and ultimately inspiring was to observe how our country attempts to deal with its past, and to do so in a way that is fair and honorable for all concerned. On a wider basis, I've stated for years that the number one societal issue facing Canada is the need to heal and improve the relationship with our Aboriginal people. I'm not the only one to give priority to that, those people who number about 1.3 million individuals. A major reason for the deterioration in Canada's relationship with its Aboriginal people was, as mentioned, the IRS experiment. That's the reason why we should know about and understand the IRS story and its consequences, because we cannot afford to let the broken, wounded relationship continuing by doing nothing more than our present efforts. In this lecture, I can't cover, obviously, all the issues and ramifications involved. I begin my remarks with the tragic past by a brief description of Indian residential schools, what they were, why they came into existence, where they were, who operated them, and when and what problems emerged from them. Next comes a discussion of the preliminary efforts to address the IRS legacy and the achievement of a settlement of the IRS claims. That settlement is the beginning of a hopeful future. The hopeful future theme is then followed by a short discussion of the Truth and Reconciliation Summary Report, and I emphasize short discussion. And finally, my concluding by having given you some comments and personal views of my own. But for an excellent discussion of the IRS, from different perspectives, I refer you all to a special edition of the University of Toronto Law Journal, 2014, that was co-edited by the Provost of Trinity and Professor Kent Roach of the University of Toronto Faculty of Law. It's an excellent compilation of different perspectives on the subject. Indian residential schools were set up by the Canadian federal government in the late 19th century and were mostly in the western provinces of our country. However, there were schools in Ontario and Quebec, as well as the 3 territories, and a few in eastern Canada. There are about 130 schools in total, with 150,000 was estimated students who attended these schools from the 19th century through nearly 2/3 of the 20th century. There were similar schools in the United States and Australia. If you read the book, The Rabbit-Proof Fence, it's a good read, and that was made into a film that starred Kenneth Branagh. That describes the Australian experience. Under the Indian Act, the schools were compulsory for Aboriginal children to attend, and they were set up, in short, to assimilate the Indian into Canadian society. The means chosen was to take the children away from their parents and homes and send them to school for periods of time up to 12 years. The students were forbidden from speaking their native languages and practicing their spiritual traditions. Quite often, the hair of both boys and girls was cut short, and they were given numbers instead of names. In the words of senior Canadian officials and leaders, the purpose was, quote, to beat the Indianness out of the children, to kill the Indian in the child, to elevate the Indian from his status of savagery, akin to the role, and reminiscent of some Christian missionaries in various parts of the world. In 1847, a great church leader in Canadian history, Egerton Ryerson, after whom the university, many churches are named, said this, and I quote, "The education of Indians consists of not merely of training the mind, but of weaning of the habits and feelings of their ancestors and the acquirements of the language, arts, and customs of civilized life." But let me make this clear at the outset. I do not doubt the views expressed by many people like those that I've quoted from, who genuinely believed that residential schools were in the best interests of Aboriginal people and Canada. In other words, the goal was laudatory, but regrettably, the means to reach that goal were in many ways indefensible. The schools were all operated by the churches through four major denominations. 70% of the schools were operated by the Catholics. Next in number were the Anglicans, then the United Church, some Presbyterian, and I believe one Methodist school. There's no doubt that the students were made to feel inferior by their second-class treatment. And compounding all of this were the prevailing attitudes towards children and their schooling, which was harsh in terms of physical discipline, that by today's standards would be grotesque. Canings, and spare the rod and spoil the child, comes to mind. And further aggravating the situation were not just serious physical abuse, but also sexual abuse in many cases. It's not surprising. Institutions of this kind breed that kind of abuse, sexual and serious physical. It's not surprising that disease was common and many children died. And tragically, we don't know their identities or their circumstances. And there was a widespread emotional stress as well as a sense of deprivation, of loss of family, and of course, lack of parenting. And when I mention parenting and its lack, I want to share with you an example which moved me profoundly. After my appointment in May 2005 as the federal representative to reach a settlement, as Mayo mentioned, of the claims, I visited the Skageen First Nation Reserve in Manitoba and participated in a ceremony on Powwow Island in Kenora, near Kenora in northern Ontario, dedicating the process to reach a settlement. While there, one of the chiefs, whose parents had attended residential schools, told me of a conversation between him and his father, who was then on his deathbed. With tears in his eyes, the father apologized to his son. This gets me every time I say this. "I never could tell you how much I loved you. I could never act properly to you as a father because I never learned how to say, I love you or be a good father to you." Now, understandably, that story greatly affected me. Can any of us imagine not having parents or grandparents around as a child, what the feelings were of those parents and loved ones who often never saw their children for long periods of time because the schools quite often were far away? Most of us simply cannot comprehend that. That was an intergenerational effect, loss of parenting. Those students didn't learn how to become parents. Even if you're in a dysfunctional family, you can learn from mistakes. And we all know people who rose above bad family situations because they saw mistakes being made and surmounted them. Another moving story involved a woman who recalled getting her first ride in a car when she was a young girl of 8. She thought she was simply going for a ride in the country. Unfortunately, she went off in a car with a priest who took her to a residential school where she stayed for the next 5 years. Her hair was cut short and she was given a number. In recalling some of her experience, she said this: "It's not even about the beatings or the humiliation of losing my identity and even my name. The first thing they did was cut off all our hair. Then we were given numbers, as I said, and my number was 52. Regrettably, there are thousands of stories like this, and many have had their accounts written up and will be preserved for, hopefully, for others to see. And all of these accounts make for very sad reading. But there was a slight beginning of a hopeful future insofar as all of this was concerned, in the emergence of the Indian residential school as a public issue more generally in the early 1990s. And that discussion was led by the National Chief of the Assembly of First Nations, Phil Fontaine, himself a former student, who publicly admitted that he was sexually abused as a student. He was also very balanced. He also said some good things about the school. His brothers went, they learned to play hockey, for example. Incidentally, today he's being honored, most appropriately in my view, at the opening of the National Center for Truth and Reconciliation in Winnipeg. He's deservedly being honored because, in my opinion, he was the key person in getting a settlement of the legal claims that I will discuss. In his public commentary, Fontaine outlined a number of the very negative experiences and consequences resulting from the schools. And gradually in the 90s, individual legal claims in the thousands against the federal government and the churches were commenced. All this litigation was unfortunate, but it did trigger a number of reactions and efforts to deal with the systemic wrongs that were committed under the IRS system. These have been discussed in many articles. These preliminary initiatives, these initiatives include enlisting others in their aid. The Canadian Bar Association was involved, academics. There were preparation of a report with proposed settlement provisions, and a political agreement between the Assembly, First Nations and Canada, which in turn presaged the components of a settlement package that included the concept of a Truth and Reconciliation Commission. And there were various statements that the federal government issued at various times, and a dialogue was really underway. And coming out of these discussions was a so-called alternative dispute resolution, an out-of-court process designed to be user-friendly, not the courts. The courts could be intimidating to a lot of people. And this was to be more sensitive to the people who would be appearing for claims of sexual or serious physical abuse. Unfortunately, the ADO system, this alternative dispute resolution system, created a big backlog, and despite its user-friendly approach, became a focus of concern. The Royal Commission of 1966 made recommendations in this period of time for public inquiries and truth commissions, and instead, count I was told over between 15,000, 20,000, up to 30,000, as Mayo said, individual actions were commenced, and 23 class actions were launched. Faced with all this, a real sea change occurred in the federal government's policy in May of 2005. The government announced a comprehensive approach to resolve the Indian residential school legacy, and that included a number of components that were part of a package for settlement of legal claims. There would be financial compensation for each person who attended the school. This was novel because any compensation only came out of serious physical abuse or sexual abuse. This was an automatic payment they were proposing. This was historic and quite unusual. And then they would also announce that healing and commemoration funds would be available for former students and their families, as well as a Truth and Reconciliation Commission, and improvements to get rid of the backlog to the alternative dispute resolution that had a backlog, to make sure it was efficient, fair, and effective. Legal fees for lawyers were also mentioned. Again, an inducement to get a settlement. And there was also special mention for the elderly or sick, but not elaborated on. Special consideration for those students, former students who were older or seriously ill. I was appointed the federal representative to lead in the settlement discussions on behalf of the federal government. Before I accepted the appointment, I talked to two people. I talked to the Minister of Justice, who was a colleague of your Chancellor, the Attorney General Irwin Cotler, and I talked to Phil Fontaine. Why did I talk to those two people? I wanted to make sure they were committed to a serious effort to reach a settlement. I didn't want to be involved in another half-baked kind of commitment to do something and it would die because of lack of really serious commitment. I didn't trust, it's not that I mistrusted them, it's just that I wanted to hear in my own ears that commitment from both of them. And I got it. I was not called a negotiator, I was called a federal representative, but I was a negotiator. It was my task with the representatives of the former students, legal representatives, to find a way, as was said by Mayo, of arriving at a fair and honorable settlement, which could be the basis of bringing most of these legal actions to end, but would also be going directed to the future and a future relationship. Now, I never had a blank check to sort of say, well, whatever you want, you'll get, and then I'll have the government write the check. And I shouldn't have. I'm not an elected representative. I don't represent the people. I was representing the government. The ministers had to make the call. The cabinet had to make the call. But I also made it very clear, not because I was precious or silly about it. I said, look, I can't go into negotiations and say, this is what the limit is. Take it or leave it. That's not negotiating in good faith. If there were good reasons why something should be changed, I felt duty bound to go back to the ministers and say, look. And so the ministers accepted that. I reported directly to the Deputy Prime Minister, Anne McClellan. She was very, very good, I can say this. This is not partisan, this is a fact. She was very good. And I did go back on a number of cases. And she listened, asked the right questions, and I'm happy to say I was not refused. I didn't go back 15 to 20 times, but I went back a number of times on very important issues. So we then, after my appointment, we went into intensive negotiations for 6 months. Many peaks and valleys, up and down. But we were fortunate in November 2005, we got an agreement in principle among all the parties, and as Mayo said, 70 or so signatories to the agreement in principle. Now that was an inflated figure. Why? Unlike the Anglican Church of Canada, the United Church of Canada, there's no such thing as the Catholic Church of Canada. So there are 44 Catholic entities that signed, 44 dioceses, orders, and so on. So the number got greatly increased because of that. There were also Aboriginal organizations, the Assembly of First Nations, and of course the Inuit, who signed, and the federal government. The process was intense, it was emotional, and at times, I admit, unwieldy. There was not always unanimity within one party. The churches didn't always agree, that's unnatural. Some of the First Nations didn't agree, and some of the lawyers, different representatives didn't agree. And often we had 65 to 80 lawyers and representatives in one room. That's not an enjoyable way to spend an evening. We met in cities across the country. That was important because it was a pan-Canadian set of issues. It's just not going to be central Canada based. So we met in Vancouver, Calgary, Edmonton, Saskatoon, Toronto. It is the largest settlement. It is probably going to reach $5 to $6 billion when it's all added up. And these components of financial compensation, $10,000 for 1 year or any part thereof to a former student for the first year, and $3,000 for every year thereafter spent in the school. Now, there's no payment that can make up, no financial payment can make up for this kind of loss of liberty and growing up in crucial time of a person's life. How can you compensate that? You can't, but you can recognize it in a monetary way, and that was the point. there is, with an estimated total student survivor population of 80,000, the average school attendance was 6 to 7 years. So the total amount for the common experience, it was called payment, is about 1.7 billion. It was estimated to be about 2 billion, but it turned out to be 1.7 billion. And up till now, the federal government has paid payments to about 78,000 former students, an average payment of $20,000, and more than 22,000 claims were rejected. Now, there was this advance payment that was made. This was one of the most important parts of this, I think, settlement. To each survivor who was at May 30, 2005, 65 years or older, the advance payment was to be deducted from any amount payable to the individual in the event of a settlement. There was no settlement then, but there would be a payment. And it's remarkable that the federal government agreed to this. And this was one of the things I went back to Deputy Prime Minister on, when there was no assurance that a settlement would be reached. What's the reason? Well, many survivors were dying at a death rate of 4 to 5 a day. The longevity of Aboriginal people is not that of non-Aboriginal people. It's much shorter. And that was the greatest incentive to try to get a settlement as quickly as we could. It's a terrible incentive for a deadline. It's terrible to have that. But it was hoped that also that the terminally sick could be also included, not just age. But you know, one of the things I checked with a leading epidemiologist. It's very difficult to define terminally ill. You may have some sort of condition, but you die from something else. So you would be including someone and then excluding someone else, might have a different condition, and it was decided to go with age as the best indicator. And that's why the advance payment was agreed to, by the way, just after our negotiations commenced, as a signal of good faith and seriousness on the part of the federal government. It was a very key decision by the federal government. And then there was funds for healing, 120 million over 5 years that was allocated to the Aboriginal Healing Foundation, which has done a very good job for those that suffered traumatic experience and those relatives who were related to students. And then there was the really important Truth and Reconciliation Commission that would have events across Canada, 7 national events, to educate Canadians as to what happened. What's the truth? Without truth, there can be no reconciliation. Simple as that. An opportunity, voluntarily, for students to come forward. And we looked at many models, the South African model. Why did we not adopt it? We didn't want to have this turn into a lawyer's arena for complaining about this and objecting to this. Let those who wish to come forward, come forward. Have the governments cooperate by providing records, and the churches with providing records. No power to subpoena witnesses. And that model that Truth and Reconciliation was to be given $60 million that was extended through negotiations over five years. And the TRC was to be responsible for administering $20 million for commemorative projects and activities, again, at the local and national levels. And then there was great improvements to the alternative dispute resolution process for sexual claims and serious physical abuse. And there was a monitoring committee. You should know that Provost Moran is the chair of the oversight committee that monitors and reviews the work of the independent assessment process. A very important monitoring role that committee plays. And the independent assessment process has so far some 38,000 claims have been lodged, 33,200 have been resolved, 4,800 have been rejected, 25,482 hearings, with total compensation amounting to almost $2.9 billion. It's amazing. And then there was the payment of lawyers' fees, which was the fifth component, which was substantial. Substantial, because these were the lawyers for all the individual actions and the class actions. The churches together agreed to pay about $125 million, which is considerably less than the 25% liability that the Supreme Court of Canada decided in a case some years ago, that the churches were responsible for 25% and the federal government was responsible for 75%. And one of the considerations in this matter was the fact that for those churches to pay their full legal share, it would have bankrupted many of them. And this is the compromise you take. For the present generation, yes, making up for something the previous generation did, but does it have to do so to the extent of being punished? And that bankruptcy would have punished those churches. And I have to say, I was pleased that the federal government did accept my recommendation that this should be avoided. There was a limit. And the government would absorb the deficiency. So as I say, you add it all up as $5 to $6 billion. And then, of course, just to add more complications, after the agreement in principle in November 2005 was reached, change of government. The Martin government, who were the designers of this, left office, and the Harper government came in. And the Minister of Indian Affairs, Jim Prentice, was in charge of the file. The new government carefully reviewed, made some changes, approved the advance payment, and approved the agreement in principle. The settlement agreement was reached, and then that was their prerogative and their right to review it. And then the next stage was to get the courts to approve it. For class actions, if you settle, you have to get courts to approve the settlement. Complicating this was the fact that there were the courts of 9 jurisdictions involved in getting approval. 6 provinces and 3 territorial governments. This made history. The courts of those jurisdictions were just remarkable. They got together. They'd never done this before. They got together through teleconferencing and indeed in person and made some comments and had the imagination and commitment to try to do this properly, and they did. They eventually made some comments, the modifications with relatively few, and they approved the agreement in all 9 jurisdictions. This was historical and quite remarkable, and it's a tribute to the men and women of those courts. Now then there was the apology. Now it was contemplated that an apology would be made, but it was not part of my negotiations. The churches were way ahead of the federal government. The Anglican Church and the United Church did apologies well before, and they were ahead of the curve. A government apology is a prerogative of government. It's not up to a negotiator. That was my view, but that's what I assumed. It's up to the Prime Minister, I believe, as a prerogative. Second, I thought to negotiate an apology is to rob it of genuineness and sincerity. It takes away the impact of what you're trying to do. What about this word? What about this? It vulgarizes it, in my opinion. And thirdly, you can only have an apology after you have a settlement. You can't have an apology sort of in the thin air. It would prejudice the government's position, arguably, if you apologize for something. So it made sense. And so when the settlement agreement was approved, the announcement of the Truth and Reconciliation Commission, the Prime Minister in June 2008 announced the apology in Parliament. What was another historical event for our country, in my view. I think the apology was sincere and genuine. It was one of the most moving events I've ever witnessed. The Prime Minister spoke, the leaders of the political parties, but most impressively, all the Aboriginal leaders of our country, led by National Chief Phil Fontaine, the Aboriginal leader who inspired, persuaded, and toiled for decades to reach a settlement of the Indian residential schools. All of them spoke, and they spoke most eloquently. So when I studied all the damage caused by the Indian residential school system, I was appalled by the taking away of children from their parents, the efforts to assimilate children and to treat them as inanimate second-class citizens, to expose many to serious physical assault and sexual assault, in short, the inhumanity of it all. But I have to say, the settlement agreement and the apology taken together is a way of Canada saying we're genuinely sorry. And we hold out our hands in the hopes of forgiveness and of trying to find a way to live together in peace and harmony. To do that, the Truth and Reconciliation Commission was called on to play an important role to permit the truth of what happened to be known to all Canadians so that real reconciliation can be achieved. And that now I want to go to the Truth and Reconciliation Commission. The settlement component of a Truth and Reconciliation Commission was of great importance. And a major reason for that was because it was oriented to the future and the building of a more constructive, positive relationship. The other settlement components that I've discussed were chiefly remedial for past mistreatment and wrongs. But the TRC establishment would not have been possible absent the remedial measures that were a part of the settlement. More specifically, the TRC was thought to be of prime significance by the Assembly of First Nations, the federal government, and the churches. And here I would say, notably the Anglican Church and the United Church of Canada. These two churches were leaders, and I have to say, for my account of this, in my opinion, they contributed significantly to the structure and mandate of the Truth and Reconciliation Commission. It's also noteworthy that the lawyers for the claimants were not that interested in the Truth and Reconciliation discussions compared to those, the AFN, the churches, and the federal government. They were really looking for, as lawyers do, for redress for their clients. That's their role. But as I mentioned earlier, different models of truth and reconciliation were studied, and we chose a model of voluntary participation and collaboration by the federal government and by the churches. We also left a wide room for the Truth and Reconciliation Commission to create protocols and procedures that they thought were necessary. We didn't want to be too rigid in the mandate because that would corner the Truth and Reconciliation Commission, who had to do the job. So we had the sense to leave wiggle room for them to be able to carve out roles that we could not anticipate. The commencement of the operation of the TRC, however, was not without its challenges and some disappointments. Initially, the first three commissioners, although dedicated and committed, encountered some disagreement among themselves and eventually resigned. I was asked to chair a committee to find replacements, and our committee recommended the three: Mr. Justice Murray Sinclair as chair, former Chief Wilton Littlechild, and Marie Wilson as commissioners. They have worked tirelessly and effectively over the last 6 years to produce their summary report. Unfortunately, disagreement emerged between the federal government and the TRC over the access to government records relating to the Truth and Reconciliation Commission. These disputes took time and required judicial intervention on a number of occasions. However, the TRC made substantial progress, consulted widely, holding 7 national events across Canada, which were amazing in many respects. And I attended the last formally one in Edmonton. And like the apology proceeding in the House of Commons, everyone was greatly moved hearing the courageous, candid, and lucid comments of former students and relatives of former students. The recently released summary of the final report of the TRC is a most comprehensive statement of the Commissioner's activities, methodology, history of the IRS, its legacy and issues and challenges, which leads to the TRC's 94 calls of action, to action. They don't call them recommendations, they call them calls to action, which I find interesting. A concluding section of the report is a very persuasive discussion on reconciliation. What does that mean? Which is the main pillar for a hopeful future for Aboriginal people in Canada. And I'm not able to deal with this summary report. It's 300 or so pages. It's very, very, as I say, thorough. The final report is being prepared. An overview of the report is even difficult to do. Let me just say this. The Commission has done a superb job in producing a thoughtful, challenging, comprehensive, well-reasoned summary of what reconciliation is and what it entails. The calls to action reflect what the Commission believes has to be done. They're divided into various headings. They'll be familiar to you. Child welfare, education, language and culture, health, justice, and things like the UN Declaration of Rights of Indigenous Peoples, the Royal Proclamation, and so on. But utmost important, number one call to action, in my view, is number 53, which deals with the establishment of a National Council for Reconciliation to be enacted by legislation through Parliament as an independent oversight body to monitor, evaluate, and communicate publicly regarding progress on reconciliation, matters and action taken by all sectors of Canadian society. This is a most crucial subject. Nothing has been studied to death more than Aboriginal issues in our country. Nothing has gathered more dust on bookshelves than Aboriginal reports on those kinds of issues. This is crucial, not because it takes away the parliamentary role, the legislative role, the executive's role, but accountability is every bit as important in ensuring progress is made. And this is a mechanism for accountability, to have a national council. This is the way in which debate and the public can be informed, and transparency can rule as to what's going on this most important issue. And it's clear to me that the work of the TRC has fulfilled the promise of the parties to the settlement agreement, and they are to be congratulated for that. But particular recognition and commendation are deserved also for the many former students and their relatives who courageously and so impressively appeared before the TRC. Their accounts can be viewed as the seeds of change for a hopeful future. I want to conclude let me just say before going on to my conclusion, it is interesting to note that public reaction to the summary report has been favorable, with 7 out of 10 Canadians agreeing with TRC's characterization of residential schools as cultural genocide. And most Canadians support its recommendation, but at the time of the poll, didn't anticipate the federal government taking any action. This is not a partisan statement. That may no longer be the case, because that was taken before the poll was taken before the election. And we know that the Prime Minister designate, Mr. Trudeau, has gone on record as supporting the summary report. I end with some personal views. In doing so, my observations are mainly to reinforce the analysis approach and proposals of the TRC's summary report. For many years now, I've been of the view that although complicated as Aboriginal issues are, the basic challenge arises because Canada's treatment has been one of destroying any real chance of a positive relationship with Aboriginal people. That has contributed to the lack of respect and therefore mistrust between Canada and its Aboriginal people. No human relationship can be enduring and harmonious without respect. And without respect, there can be no trust. And thus, there can be no harmony and peaceful living together. To gain that respect and trust, we cannot simply proclaim it. Although proclamations can serve a useful purpose of emphasizing the commitment to do better, but rather we need to earn the respect and trust by our conduct and actions to give our words integrity and real meaning. All the ingredients necessary to reflect a sincere dedication to gain that respect and trust are forcefully expressed in the summary report. We now have a prescription to apply to the diagnosis of a ruptured relationship. From my experience, we need to achieve a new relationship with our Aboriginal people, which I have called partnership. Partnership in this context means living and working and sharing the land, resources, opportunities, and challenges. It means turning our backs on unilateralism, exploitation, and neglect. It also means replacing an adversarial relationship, ending in a courtroom, with a collaborative one that perhaps can begin and end with a traditional Aboriginal ceremony of celebration and hope. At the political level, we need to firmly and unambiguously accept a government-to-government relationship between the levels of government in Canada and Aboriginal governments. Although the efforts to amend the Constitution to provide for Aboriginal self-government failed, de facto Aboriginal governments do exist and should be formally recognized. This will be further evidence of a genuine respect for Aboriginal people and their communities. To achieve reconciliation and improved relationship will take time and patience, with the commitment from all of us to join in that mission. This issue affects all Canadians, not just our leaders, and we have to collectively educate ourselves about the original people, their history, traditions, and values. In doing so, we not only will learn about them, we will learn from them. To have played a role in this matter represents the most satisfying experience I've had as a lawyer. And I thank the governments of Canada and all my colleagues from all the parties who worked to achieve the settlement. In particular, I want to single out the churches I've already praised and the many lawyers who worked tirelessly for their clients to bring these claims forward. Most importantly, I thank the former students, again, for their courage and patience in waiting for some recognition and some justice to be given them. Let me conclude by a very personal recollection. At midnight on November 20th, 2005, we finalized the agreement in principle for the settlement agreement. It is clearly one of the most exciting emotional, personal, and professional experiences of my life. All the parties signed the agreement, and Phil Fontaine, on behalf of the AFN, and I, on behalf of the federal government, were the last to sign. After we did so, joyful applause erupted, and Phil and I had a long embrace with tears flowing. These were tears of happiness, relief, and above all, hope, in a belief that we were all on the pathway to a better future for Canada and its Aboriginal people. The legacy of Indian residential schools reflects a tragic past, but recognizing and responding to that past reveals a hopeful future. To build a Canada that all of us, Aboriginal and non-Aboriginal, can, by working together, be proud of, and thereby for Canada to be a model for the Indigenous peoples of the world. Thank you very much.
I suspect there were more than a few tears being shed with Frank's last words, and I want to thank you so much again, Frank, but don't go too far because I think I talked you into answering a few questions. And so we have a few moments for questions. If anybody would like to ask any questions, we have a couple of minutes. Yes, there are mics. Sorry, I should have pointed that out. Thank you.
I don't have a question, but I have a comment of thanks. I work for the Anglican Church, National Church, and my title is Program Assistant Residential Schools. That means I have read over 9,000 claims and made payments up until the payments were finished. And now I'm still involved in receiving claims, sending representatives to hearings, and writing apology letters on behalf of the church. I give great thanks to God and wisdom of the government in appointing you to this task. It was an amazing feat for you and for all of us. I worked for the church when the settlement agreement was signed, and it was a great day. I also have a much more personal connection. I graduated from University of Toronto at age 51, finally, with my Bachelor of Arts in Anthropology Native Studies, and you signed my diploma.
Justice Iacobucci, you've said that call to action number 53, the Monitoring Council, is in your thinking the most important call to action. Justice Sinclair has talked about number 45, the Royal Proclamation. I think he's talked about it as his primary, I think the word he uses is his primary call to action. I have troubles understanding what a royal proclamation would be and what it would look like. And I wonder if you could help us try to frame it. Is it something constitutionalized? Is it something in law, something symbolic? What does it mean? What do we have after it's put in place?
Well, I'm not going to get into an argument with Justice Sinclair or what is the most important. His opinion counts a hell of a lot more than my opinion on. But what I like about mine is that it includes the Royal Proclamation. So that's what I don't mean to be facetious, Michael. I just want you to know that that's why I like it subsumes everything that they say. I think the Royal Proclamation, it has a very powerful symbolic effect. I'm not going to give you a legal opinion on it. I'd have to think about that. We have constitutionalized our treaties and Aboriginal rights. This doesn't seem to be having an enshrinement in the Constitution, but it probably is to sort of update the old proclamation and give it a modern context. And I don't quarrel with that. I think it has a great significance.
Thank you.
Justice, Aboriginal. Oh.
Even Ivan has to use a mic.
I hope I use it properly because Harriet tells me I don't speak into the mic. Justice, Aboriginal governments are de facto. How do you see them operating with the federal and provincial government, given the constraints of the Canada, the Constitution Act? Would they be superior to? Would they be equal to? Would they be outside the law? We have very good friends in British Columbia who maintain, for instance, that the maple leaf should not be on the flag because the maple leaf doesn't grow west of the Ontario-Manitoba border. No, that sort of fundamental kind of thing. And he has raised this issue that with the property settlements over the years, the Aboriginal peoples are given such power that eventually the federal government and the provincial government will be held in abeyance or in check.
Well, I worked on the efforts under the 81-82 Trudeau-led amendments. I worked in the Justice Department on an amendment to the Constitution for self-government, which failed, just narrowly failed. And we were willing to put in the language of the Constitution that there would be a Aboriginal right to self-government. There was a lot of argument whether there's an inherent right to self-government. There still is a lot of argument about that. And we were able to say this is something, like we put in Aboriginal treaties, we put in Aboriginal rights. There's a lot of things that go in constitutions that are not defined precisely because there's an organic nature to the law and to society. As Viscount Sankey said in one case, the Constitution is a living tree. That's our model. We don't subscribe to the original intent theory of some people in the United States. And I'm not criticizing. They're smart people. They have a wonderful they exported federalism to the world. They exported a Bill of Rights to the world. So I take them seriously. But so the answer to your question is this can evolve. If people de facto recognize something, remember we have conventions still around, we have practices and customs, so I wouldn't get uptight about self-government. We'll let it evolve and let it see. The fact of the matter is, you go to some reserves and you go to the Akwesasne, and there's a Department of Social Welfare, there's a Department of Justice, there's a department of, a police department that points to a director of policing, like a minister, sort of internal security or something. So, I mean, it's going on, it's going to evolve, and the more we recognize that and let it be organic, we will, I think that's the right pathway to go.
Sure. Thank you so much for your talk. I'm a first-year law student at U of T Faculty of Law. My question surrounds the duty to consult and accommodate, which has been set forward by the Supreme Court. I'm wondering, though, the Truth and Reconciliation Commission's report calls for adopting the standard of free, prior, and informed consent set forth in the UN Declaration on the Rights of Indigenous Peoples. What's the relationship between this standard and the duty of to consult at the Supreme Court?
Hey, I'm glad that the law school of this university admitted you to their law school. That's a very good question. There are some that argue that there's no difference. That free, FPIC it's called for short, isn't it? And some would say that it's the same, that it's basically a duty to consult and accommodate. I think that, again, this is emerging. The Supreme Court has given some guidelines on this, which that's the role that the court should provide, and I commend them for it by giving guidelines. Don't fill in. As someone once said to me wisely, there's a line and then there's a space between the next line, eh? Don't fill in the space. Leave it for evolution and experience. And this will all work out. Not a very certain answer, is it?
He left some space. I think we have time for one more question, so thank you.
Thank you for joining us tonight. I noticed when the Truth and Reconciliation recommendations came out last summer, there were a couple editorials and column pieces. I won't name any names, but I sort of noticed a troubling attitude in those, which was essentially, I would describe it as the past is the past and we need to look towards the future. And focusing too much on the past can sort of create negative relations and unrealistic expectations. So how do we respond to that negative attitude as a Canadian society, and how can we overcome that attitude to achieve meaningful reconciliation?
It's an excellent question, too. I don't have any magic formula. I'm a great believer in the basic makeup of Canadians. What was I reading the other day? That Canadians are known for two major things: hockey and apologies. And there's something in that. There's a civility to Canada that I'm proud of. There's a compromise to Canada that I'm proud of. Not compromise for a weak-kneed sort of middle ground or with no integrity, but for giving and taking. And part of that is educating ourselves. Education is a great leveler for all of us. Certainly was for me, I'll tell you, and for many thousands of others. Let's get the facts out there. Let's get the truth out there. Let's get understanding. And not knowledge, but understanding. There's the difference between knowledge and understanding. And I'm convinced Canadians, once they know, when I was briefly in the Justice Department, when there was an issue about, well, we're doing all these things for refugees and immigrants. But then there would be a story, and then so where were we doing all these things? Then you get a story of a terribly emotional situation involving a family, the loss of somebody, and making an effort to come here, and so on. And then all of a sudden, the Canadians find the truth, and they say, why can't we help that person? So I don't mean to say that we're a nation of just emotionally overcharged on these issues. We're rational. But we also are, people that think, but in other words, we have brains and we have hearts. And I think the combination of the two will operate in the long run to say, look, we can't let 1.3 million people exist where they presently exist. We've got to do something, and it's going to take time. No quick fix. But once the truth is out there, more people get understand. Education is a big call to action. But it's on both parts. I've done work on the justice system. Justice system of our country, I am immensely proud of the men and women who serve at all kinds of capacities. But we haven't done a great job with our Aboriginal people. It's a fact. We've got to do something. The Supreme Court on 2 occasions has said we've basically failed in that respect. But we're going to keep trying. We're going to keep trying. And over time, I have confidence in the new Canadians that are coming around and the young Canadians that are coming around, that this will be. We will find ways. It may not be my children that see it, but I'm confident that my grandchildren will see a changed Canada. I've seen a lot of change in my time, and Bill's time, and Stephen's time, and Toop and Stephen Autumn's, just to mention law professors who are a discrete and insular minority. But I'm confident.
Well, I still have to call him Justice Iacobucci. I just can't help it. But when he was making opening remarks, he said he looked at the list of people who had delivered this lecture and felt sort of awed by that list. But I'm sure that I express the feelings of everyone in this room when I say that I don't think there has been a more important Larkin-Stuart lecture, and that's a high bar. And I think you sharing with us the experiences, your insight, and the understanding and the heart and the brain, as you said, of this issue that really is at the heart of who we are as Canadians has been a very, very special moment for us. And as the Larkin-Stuart lecture, Trinity College, St. Thomas Church, we're very, very happy to have hosted it. I ask you to join us to continue the conversation, which I'm sure you will in the buttery just outside. And Justice Iacobucci, thank you so, so much.